And we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel this morning are Justice Mary Sullivan, Justice Young Shin. We will be the panel for all 6 cases that are on the list for hearing today. The first case on our list for hearing is case number 2020 P50, the Commonwealth versus Christopher F. HOIME. Attorney DeJunius.
Good morning, Chief Justice Green, Your Honors. May it please the court, Patty DeJunius for Mr. HOIME. I want to start with the first complaint and closing argument issue. They're intertwined, but if I'm prepared to answer questions on both issues. On the first complaint issue, there's no doubt here that there were credibility issues both for Mr. HOIME and for CR. Mr. HOIME had not been honest with the police, and there were multiple factors which a jury might have issues with regard to CR, including, she admitted that she hustled men for a living, that she had asked for money for her car payment, that she had been drinking, things like that. So this really was the ultimate credibility battle. From the very beginning, from opening statements straight through to the closing arguments, it was clear that the Commonwealth always intended to use CR's multiple complaints to corroborate her credibility. In the closing argument, I mean, she just came right out and said it. If they've always said the same thing, if they've always given the same account, or if their story has changed. So this was not inadvertent. I think it was the plan all along, and it made for a pretty powerful closing argument. It was all about corroboration. She told this person that corroborates this, and so on.
In the closing argument, wasn't the prosecutor's closing in at least in part a response to the defense efforts to draw out inconsistencies between the accounts given to various other witnesses?
That's what the Commonwealth argued, Your Honor, but that's just not the case. The only thing that they pointed to was when defense counsel pointed out a single omission from what CR had told the nurse, and that was that she had smoked a cigarette. It was mentioned almost in passing. It wasn't a theme. The theme was that she was motivated to lie by 2 things. Number 1, money, and number 2, her relationships with Mr. Fink, Jose, and Isaiah. So that's the thrust of the argument. There was no inconsistencies pointed out between what she told the nurse, what she told Detective Moody, except for that one omission, which is really inconsequential in the context of the entire case. And you also have to go back and look at the opening statement. This was always the plan. It wasn't only in response to something that the defense counsel said. It was opening statements, the evidence. I don't think you could say that it's fairly in response to defense counsel pointing out that she had not told the nurse that she had smoked after the events. There are fundamental
Let's move to the first complaint testimony itself, because the propriety of the closing argument is going to depend on the propriety of the evidence. So I appreciate the point you're making. If it was improper, then the closing, we would look at the closing one way. But let's just take it from the top. With the same nurse, you don't argue, do you, that it was improper for the same nurse to testify that she'd received a complaint of sexual assault?
No, I think that most of the nurse's testimony was just fine. The problem is that both the SANE forms and the nurse's testimony interjected facts into her testimony that had nothing to do with diagnosis, treatment, or the SANE process. And by that, I mean the location of the hotel, that it was a male acquaintance, that there had been drinking, and she threw 2 drinks away.
Okay, let's take those one by one then. The location of the hotel. I take your point that that's not relevant to diagnosis or treatment. As to the first complaint piece of it, Since that is undisputed, what's the harm?
Well, it is undisputed. Mr. HOIME's testimony matched CR's in many respects. However, that evidence was the factual foundation for the prosecutor's closing argument, which was, look at what she said to the nurse, look at what she said to Fink, look at what she said to the nurse, look at what she said to Detective Moody, and look at what she said here in the courtroom. So it's the way that the use of the evidence was not to establish something that's independently admissible. It was used so that the prosecutor could then argue. I understand Your Honor's point about, first the evidence has to be improper for the closing argument to be improper, but I think it's appropriate to look at the closing argument to see why the evidence was offered and admitted. And
but if it's consistent on a point that's not disputed, what difference does it make?
Because the theme of the prosecutor's closing argument was over and over, she told the same story.
But the use of that in the closing is not improper if the evidence itself was not improper, and the evidence is not improper if it came in on something that was not in dispute.
Well, I'm not sure that I agree with Your Honor, because the mere fact that a complaint is made, the SJC said over and over again that that's extremely prejudicial. So it doesn't have to be a repeat. It's the factual foundation to argue she told the same story over and over again, and that's not proper. That's not the proper purpose under the first complaint. So certainly wasn't sufficiently important to the Commonwealth's case. It did not serve a purpose other than corroboration. That's the second factor in determining whether something is independently admissible or not.
Let's move on to this, because there's a lot of ground to cover here. Let's move on to the other aspect of the same nurse's testimony, that the perpetrator was male, that she had been handed drinks. Is that not relevant to diagnosis and treatment? Does not that touch upon whether or not they're going to look for sperm, whether or not they're going to look for her level of alcohol intoxication or other form of intoxication?
So the testimony and the SANE forms don't just say it was a male, it says a male acquaintance. And with the drinks, the nurse did mention that briefly, but from her testimony, it seemed clear to me that the real reason that she did the toxicology screen was because CR couldn't remember what happened. And that's fair game that she couldn't remember what happened, but to recount the details of the story, the same story that she told over and over again, shows that this was not admitted for an independent purpose. It was admitted to be able to make that argument. And so that's the true purpose, is my point about referring to the closing argument. The true purpose was to show consistency between her various complaints.
All right. So my next question, and then I'll let you argue unencumbered for a bit, is if it is permissible for the same nurse to testify that she was responding to an alleged sexual assault, you seem to argue that it was improper for Sergeant Moody to say that he had received from her a report of past sexual assault. Is that improper first complaint evidence to testify, to have testimony that the witness has come in to the police station to report a sexual assault?
Yes, Your Honor. It served no independent purpose either. There's an abundance of case law.
Yes, Your Honor. What's the case that says it's improper for the police officer who's testifying to his investigation to say that he received a complaint of sexual assault?
McCoy, for one, says that the details of the investigation isn't relevant to anything.
Not the details, just the fact that he got the report. That's all I'm asking for to start.
I think it's improper. I think it was offered for the purpose of showing that she told the same thing, and it wasn't
instead of going back on each occasion to what you ascribe as the purpose. I think we need to go to the propriety of the evidence itself without looking at the reason that the unit said yes, the prosecutor was trying to get it in. And I want you to go back to Judge Sullivan's question and give us a case that says that evidence of a report made to police that initiated an investigation by the police is improper first complaint evidence?
I would say McCoy would be the main case, and the cases that say that the mere fact of a complaint is of a subsequent complaint is a violation of the first complaint doctrine.
Even made to police in order to initiate their investigation?
The investigation is irrelevant. It has no bearing on whether Mr. HOIME is innocent or not. Whether there's a foundation for various evidence was not a live issue, and much of the evidence was or could have been admitted through the hotel manager. So it's not probative of anything, and it's certainly not probative of a live issue. So
the police are not allowed to testify regarding the steps that they took to investigate the alleged assault?
I don't believe so, Your Honor, not under McCoy and its progeny. It has to be related to a theory of the defense somehow. There was no Bowdoin type defense here. Defense counsel never challenged the way that the investigation was conducted. And it's also duplicative of the hotel manager's testimony. He's the one who turned over the records which showed that the defendant stayed at that hotel. He's the one that was instrumental in locating the mirror. How Detective Moody ended up with that evidence is it's irrelevant. It has, certainly was not sufficiently important to a fair understanding of the Commonwealth's case. Really, Detective Moody his testimony should have been constrained to the statement that he obtained from Mr. HOIME. But every other step that he took, I would argue, is irrelevant, and it shows that she made 3 subsequent complaints. It was November 10th, November 11th, and in 2015, I don't remember the month, but
so
that all came in.
She says she complained, then she withdrew they testified that she complained, she withdrew the complaint, they called her, she reinitiated the complaint. Why is that evidence not relevant to rebut the claim of fabrication and to explain the delay in reporting?
Well, it has to be recent fabrication, and there's no evidentiary basis to say recent fabrication here. Her first complaint was made the next day. There was contact between CR and Mr. HOIME throughout. It's not as though...
Why does it have to be recent fabrication? Why? We're not talking about rules of evidence. We're talking about a theory of the defense. He's saying she's lying. She made it up.
Right.
And she's saying, no, I didn't. I reported it, and then I couldn't handle it, and then I came back. I'm not making it up. I was just reluctant.
But I don't think that was the theory of the defense. I mean, the theory of the defense was really motive to lie. And yes, along with that comes that this is not true. But the exception to the first complaint doctrine in this context is recent contrivance, and there's no factual basis for that. It was always his defense, including back when he first spoke to the police, that he didn't do this. And so there has to be some sort of relationship between the timing of the disclosure. And again, there was no challenge to the consistency. The argument was that she's been lying all along. And so on that basis, I just don't see that any of this evidence had an independent evidentiary value other than the fact to get into the record that multiple complaints were made. It doesn't matter whether the details of her complaint came in, just the mere fact of it. And again, coming back to the police investigation, there are multiple cases, I believe McCoy was the first, which says this has no bearing on anything. And what it does is it gives the stamp of government approval that they believed the CR. And in fact, the Commonwealth admits that it was improper for Detective Moody to testify that after the 3rd time he met with CR, he went and interviewed Fink. And they say, well, that wasn't proper because from that, the jury could infer that Detective Moody believed CR. Well, that applies to everything else too. It applies to the hotel, it applies to the hotel records, it applies to the mirror.
What about the audio tape? And then
the
we
audio
turn to GHB.
So,
is not the audio tape, is any portion of the audio tape admissible for consciousness of guilt?
Yes, Your Honor, I believe that everything other than when the detective just repeated the details of what CR said. It wasn't a back and forth. It was Mr. HOIME saying, right, okay, that part of it is improper because it repeated the complaint and it did it in detail. The denials came before they got to the details.
Well, actually, after they list all the items from her complaint, he says, but I don't even know the woman. So it's another denial. Does that matter?
I don't believe so. They could have still excerpted that out and left that in, but I don't even think that that was sufficiently important given the multiple denials that preceded the rendition of her complaint and the very minute details of it.
Counsel, in your last 5 seconds, I did want to ask you one question about the second issue. Could the Commonwealth have made an argument along the following lines? You heard from the victim that she has a very high tolerance to alcohol. And yet on this particular night, after drinking the last glass of wine that was handed to her by the bartender, she suddenly blacks out. And then later, she can't move her hands or she can't move her body at all. These are not symptoms that are consistent with drinking. They're symptoms consistent with something being slipped in her drink. Would that be a proper argument?
I don't believe so. It's the Commonwealth said something in the brief about, well, maybe somebody else did, and if somebody else did, it still would have been improper.
Why isn't it within the common knowledge of a jury what the normal symptoms of drinking are, and that the normal symptoms of drinking are not losing the ability to move your body? Why is that not something that can be argued just based on the common knowledge of the jury?
Well, I think that argument was made, but it didn't need to be supplanted by evidence that it invited the jury to speculate that something other than alcohol was in her drink.
If that's a proper argument, because it's within the lay knowledge of the jury, what is the prejudice from introducing evidence about the effects of GHB?
Well, it's the insinuation that it was Mr. HOIME who put the GHB in the drink. And it was another way that the Commonwealth argued, and it corroborates her story. Everything is, you can't introduce evidence that's completely speculative as to whether anything was in her drink, and certainly whether anything was put in her drink by Mr. HOIME. Now, if the argument had been, something was off, or, maybe somebody else put something in the drink, that's fine. But there's just no evidence here connecting Mr. HOIME to GHB or to the drink itself. So I would argue that based on the record of this case, that the evidence was improper and it just was not probative of any live issue. The Commonwealth could have argued that she was incapacitated, but that doesn't require evidence such as was introduced here with the GHB.
I think we'll have to leave it there, but thank you.
Thank you, Your Honor.
For the Commonwealth. Attorney Von Plattern, we're having trouble hearing you. Are you on speaker? There we go. That's much better.
Okay. Good morning, Your Honor. Good morning, Chief Justice Cynthia Von Plattern for the Commonwealth. With respect to GHB, which was the issue that was just upon, the Commonwealth admits that expert testimony would be helpful to the jury. Before it, evidence.
Your audio is something's going on with your audio. I think it works better with your phone up to your ear.
Yes, and I could turn off the video if.
No, this is good.
Would that be helpful?
This is good, just like that. Keep the phone up to your mouth.
Okay. Is that helpful?
Yes, please.
Okay. Thank you, Your Honor. So with respect to, I'm just going to turn this. Okay. With respect to the GHB, it would be helpful to the jury to hear information about the effects of GHB about when it leaves the body, about its additive effect with alcohol. And this was presented to the jury. It said nothing about whether the defendant had drugged the victim. I'm frozen here, but I can see you.
Keep talking, you're good.
Okay. So it was permissible, and there are two cases, 128 cases from this court that have also found that testimony, that evidence permissible.
So I'm assuming there are many other substances that could cause the same type of symptoms that the victim experienced that night. So could the Commonwealth have put on an expert to testify about the effects of each one of those substances?
Well, I think that the testimony from the toxicologist, or the knowledge of the toxicologist, would be that GHB would likely be the substance.
Why?
That's why it was tested for.
Why is it? So it was tested for, but the screen was negative for GHB. So why is it any more likely that it would be GHB versus any other drug?
Because I think the knowledge, even of the same nurse who tested, who ordered it tested, the knowledge of the medical professionals would be, this is what we would test for. You know, and then I don't know what other substances would have similar effects, but this is the one that was identified by the toxicologist and medical professionals.
It was identified in the sense that it was tested for, but it was negative for GHB. So I'm still not seeing how in this record it was established that the evidence concerning GHB would be any more relevant than the evidence concerning some other substance that causes the same type of symptom.
I think it comes down to that it was ordered, that the nurse ordered that test. And yes, it was negative, and you could say the same for alcohol. You know, it's negative, but the victim could still testify that she was, if she had been under the effects of alcohol, I was drunk and I didn't know what I was doing. I mean, that wasn't the case here, but it is in many cases.
So if they test for multiple substances and they all come out negative, the Commonwealth can then put on an expert to testify about the effects of each one of those substances?
Well, I think here, where the knowledge of the toxicologist was that these symptoms are consistent with GHB,
but
that's why you would.
It's almost like the argument is too specific, right? I mean, there's nothing in this record tying her symptoms specifically to GHB, right? But the implication of offering the evidence and the clear implication in the closing argument was that the defendant must have put GHB in her drink.
Well, there is an inference that something was put in her drink. And, you know, so what the jury has is GHB, but they didn't have to conclude it was GHB in any way. But it was helpful to have some information. Otherwise, maybe they understand the effects of alcohol, but they would not know the effects of other drugs. Perhaps a layperson would not.
That goes back to Judge Shin's question about why this one as opposed to all the universe of other possible drugs that would have similar effects.
Your Honors, I think it's within the knowledge of the nurse and the toxicologist that they would say that this was very consistent with what her symptoms were. If it was Rufinol or something else, then they would have ordered that. But this is what it looked like.
Well, that's I understand that argument. I understand that argument, but did their testimony explain why they excluded other possible culprits?
No, and I think that would have gone down a road that would be more prejudicial to the defendant. Oh, you know, and it could have been a defense of the defendant. But I think to get into all the possible drugs that it could be actually, takes it down a road that we don't have to go on.
Well, no, but I mean, if they to go back to your threshold argument, they zeroed in on GHB because they, you suggest, reached the conclusion based on what she reported that was the most likely culprit. That may be, but they didn't testify to that. They simply tested for GHB. There is no evidence from the nurse or from the expert that walks the jury through that thought process, that explains why they zeroed in on GHB as compared to Rufinol or ecstasy, or I don't know what these other drugs are, but there are other substances that they could at some point in their mental processes have considered and excluded, and should it be a threshold predicate to explain why they centered in on one and excluded others as possible culprits?
Well, I would just say, Your Honor, that may lend an imprimatur of that we're getting into something that really suggests to the jury how the professionals or what they conclude about the defendant's guilt. And we don't want to go there. We want the jury to make its own decision.
All right. Why don't we talk a little bit about the first complaint evidence?
Yes, with respect to the testimony of the SANE nurse, my sister really agrees that most of this testimony evidence does come in because it goes to the purpose of diagnosis, of treatment. And the particular issues that she has were not issues for trial counsel. The attorneys went through the forms. There was redaction of the SANE forms, but there was no redaction of where the rape took place, that it was by a male acquaintance, that she had 2 drinks and threw them away. So it really wasn't an issue at trial. There was no issue that the defendant, in fact, testified that he had sex with the victim at this particular hotel, that they did know one another, that she had been drinking. And in fact, the report that she had been given 2 drinks and threw them away really helped the defendant because it really established that she did not have a drink that he may have slipped something into when he gave it to her, or before he gave it to her.
It didn't establish that, but it tended to be consistent with that version of events that the defendant pressed. Yes.
And it is something that the nurse will ask whether alcohol was involved. That's part of their questions, and something that goes to what kinds of tests they're going to order, what kind of toxicology tests, and the circumstances of the assault.
So let's turn to first complaint. Could the police officer testify that he had received a report of sexual assault from CR?
Your Honor, I think that the police officer can testify to that. His testimony didn't suggest that he, believed her. It just was very straightforward testimony about the steps that he took.
The problem is that we have the first complaint witness, followed by the SANE nurse, followed by the police officer saying he received a first report, and then ultimately a second report. And then the capper is the interview, where the interviewing officers on audio tape repeat most, if not all, of the details of her claims of sexual assault. Even if one could say that the first 4 are permissible to rebut a claim of fabrication. The 5th, the interview, where in detail they repeat, she said, she said, she said. Does that not violate the first complaint doctrine?
Well, Your Honor, with respect to the interview itself, they had to lay out for the defendant what they were talking about. This was an incident that had occurred 2 years before.
Of investigating, yes, but that doesn't make it admissible.
Well, the record shows that the attorneys had talked about what would be redacted from the interview, and that this was not an issue at trial.
I understand. That means we do substantial risk review, but if there's error, my first question, my predicate question is, was it error to permit evidence to go before the jury of that kind of questioning?
I don't think it was error to permit it to go forward when there's been a determination made. You have to hear it in context. What they were saying was basically repeating that they went out, that they had drinks, and then they went back to the Clarion.
Well, no, they say to her, she says that she got back to the room and she couldn't move and she blacked out and woke up with him having sex with her against her will. That's what they repeat to him, and that's what the jury hears.
I think Your Honor, they repeat that to him at the end of the interview after they spend quite a bit of time saying, do you know her? Do you recognize her? Did you go out with her?
Let's assume that part is admissible when he says, no, I don't know her. But was it error? Was it inadmissible evidence to have those allegations repeated in that form?
If it were error, Your Honor, there would be no substantial risk. And I think it goes to the trial, what the defense attorney was, what the defense was. You know, he was saying this was consensual. It didn't matter to get into the specifics of it because the position of the defendant was she was lying. So I would say that there was not error to keep that question in the interview, and certainly
but the question is, risk. She says you were having sex with her against her will, not that it was consensual. So how do I appreciate that substantial risk is a lenient standard for the Commonwealth, but how do we get around substantial risk when there's a repeated allegation of rape?
I don't think it would be that prejudicial when what you're looking for in that interview is what is the defendant's answer. And I just think it goes to, they're having an interview. It's very difficult for it to make sense unless they really say what they really explain why they're there and what they need to find out from the defendant.
I see that your time has ended. That concludes the argument in this case. Thank you all for.
And we are back live and on the record.
Okay, thank you. Our next case on for hearing this morning is case number 2020-P315, the Commonwealth versus Matthew A. Lewis.
Good morning. May it please the court, Dana Kerhan for Matthew Lewis. This case involved a shoving match and fight between two older gentlemen at a Burger King in Framingham. And on the day of trial, the Commonwealth advised, it appears that the Commonwealth advised defense counsel that they were going to have the alleged victim testify to two surgeries that he had as a result of this incident. There was an objection. Counsel objected that this is the first time I'm hearing about the 2 surgeries, and the judge said, in essence, well, we're not going to have she's not going to introduce medical records, so that's okay. The alleged victim then testified at some length toward the end of his testimony that he had 2 surgeries as a result of this incident. And his allegation was that my client reached and grabbed him in the genitals and pulled, and he felt something tear, and that was what he needed the 2 surgeries about. Mr. Luz testified that in essence, they were shoving each other, and he threw a punch in order to get the alleged victim away from him, and the victim deflected his punch downward toward his abdomen, and he believed he hit him in the belt area, but that he never grabbed him. So, I mean, here's the problem. I mean, setting aside the motion for new trial, I mean, it was unfair surprise to throw that on him the day of trial, on counsel the day of trial. But what we discovered and what prompted the motion for new trial is that we've got the medical records, and he had 2 hernia operations. He never had any kind of surgery for this alleged injury. There's no documentation of this alleged injury. He was a truck driver. He lifted a lot of heavy things, and he had a hernia, and that's what prompted the 2 surgeries.
Well, that's your contention based on the subsequent medical records. The medical records themselves are not entirely complete. The doctor didn't testify at the new trial motion hearing. The report is unsigned. But quite apart from that, when we look at the evidence at trial, the victim testified to his belief that he felt something tear and that he had to go for surgeries afterwards. Why is that? First of all, injury is not an element of the crime, we have 2 competing versions of the conflict. The jury were entitled to hear the testimony and assess which version to accept in terms of who was at fault.
Well, I think it's unfair surprise to say on the day of trial that, by the way, he's going to testify that he had 2 surgeries. And then we find out that the 2 surgeries, we find out later that the 2 surgeries have nothing to do with this alleged injury. Now, he may have believed it, but it wasn't a reasonable belief because a few weeks prior to this incident is when he first went to the doctor and found out about a possible hernia. And I think it was 9 months later that he had the first hernia surgery. Nothing to do with his scrotum. It was completely unrelated. Now, you know, what is the jury supposed to think? The jury hears 2 versions of this incident. The first version is he reached in and he grabbed me and pulled my genitals, and there was a tearing, and I had 2 surgeries. The defendant testified, I never grabbed him there. I just threw a punch there. Now, of course, if they're hearing that he had 2 surgeries and that he missed a month or 2 of work because of these surgeries, you know, obviously they're going to believe him, and they're going to believe him unfairly. And had this been disclosed prior to trial, this is something that would have been, I'm sorry?
I'm sorry, the Commonwealth says that it was disclosed prior to trial, that the Commonwealth moved for the documents production. The documents were provided to the court. And so there should not have been unfair surprise. What do you say to that?
Well, what I say to that is that it was not the same medical records. There was a motion, I think, well before trial for disclosure of the medical records. If you look at page 14 of the transcript, the Commonwealth says, yeah, we filed this motion. We don't think we got anything. And during the hearings, several hearings in this matter, one of them, we looked for, you know, this medical record. This issue came up, and I don't believe anybody found the medical records, and I think if they did, I think there was some discussion that there was only like 7 pages. So, and that was never disclosed to defense counsel. So there was no, if the records came into the court, they were never disclosed to the defense. And there was no notice that this was what the victim was going to testify about. And that's the problem. I mean, without
Did the defendant move for continuance based on this unfair surprise?
I'm sorry?
Did the defendant move for continuance based on unfair surprise?
No, there was an objection. This had been, I believe, it had been continued a number of times. There was an objection to this testimony, but there was no,
But an objection, I mean, if the evidence is permissible and it's clearly relevant, if the claim is unfair surprise, then you can the remedy is a continuance, not to exclude the evidence, particularly where it was at least embedded within material that had been disclosed, even if through whatever administrative snafu it was not the defendant was not aware of it.
Well, it was not disclosed to the defense. The court, neither the court nor the Commonwealth disclosed this to the
I
defense.
understand, but that goes back to the question about the appropriate remedy. You're suggesting that because the defense was unaware of it, it was in the clerk's office. Because the defense was unaware of it, the evidence should have been excluded entirely, and there was no request for continuance.
Well, I mean, I'm not sure. I don't think defense counsel had sufficient information to make that decision. All she got, at the time of the hearing, when the Commonwealth said, yeah, we filed a motion looking for medical records. But then she said, well, we don't think we got any. So the representation from the Commonwealth was that there were no records in the clerk's office. And if there, I don't think defense counsel had any reason to doubt that the 2 surgeries came from, were the result of this injury. There's nothing there. She cross-examined him a little, and he reiterated that, yeah, I had 2 surgeries because of this. And then the prosecutor went off on her closing and went into this in detail, and how it established that that he had committed the crime. This wasn't just a shoving match. This was a pretty serious injury. That's where the motion for new trial comes in, because now we discover that, in effect, the alleged victim perjured himself. And I mean, that's...
Well, I mean, again, that's a very strong statement to make based on the strength of the evidence submitted in support of your claim on the new trial motion.
I don't think it's a strong statement to make at all. I think it's an accurate statement. And, we have Dr. O'Leary's letter. We weren't unable to produce him at the hearing, but I think all he did was summarize what the medical records say. And when you look at the medical records, it is very clear that there was a hernia. I think that...
to me, I think that inquiry is something that would be an entirely appropriate subject for further investigation and exploration on cross-examination of the physician.
Well,
before we treat as established a conclusion that the victim perjured himself at the trial.
Well, I think all we have to do is look at the medical records themselves. This isn't just a few pages. This is a very detailed history going from a possible diagnosis several weeks before the incident, surgery for hernia 9 months later, and a follow-up surgery as a result of a problem that occurred during the first surgery. None of this has anything to do with his groin area.
I don't know that I can. I'm not qualified to draw that conclusion from the paper records alone.
I think if we look at those records, the records are detailed and in plain English and clear enough that clearly defense counsel should have had the opportunity to cross-examine on that particular issue, and the jury was completely misled. I mean, this trial ultimately was not fair, and you know, it was something that she recognized and objected to, but I think she probably was thinking, yeah, I guess maybe he did have the surgeries as a result of that. And I think there's a strong enough inference from those records that, and from Dr. O'Leary's letter, that, you know, this had nothing to do with, and, you know, a jury should have heard it. I mean, I think that's really the bottom line. If this was going to be let in at the last minute, if he was going to be permitted to testify at trial that this happened and this was, that the injury resulted in 2 surgeries, I think this is something that.
Court transcriber 508.
Sorry.
I'm sorry, was there a question?
No, something odd happened on my iPad.
Okay, that's fine. So I think really that's my contention. There was, it's not just the motion for new trial, it's not just the objections, but when you look at the combination of the two, it's pretty clear that this case went off the rails. And I think there really needs to be a new trial in this matter. Unless there are any further questions, I will leave the remaining points to my brief.
Seeing none, thank you, Mr. Curhan. For the Commonwealth?
Thank you, Your Honors. Good morning, and may it please the Court. Assistant District Attorney Lindsay Russell from Middlesex on behalf of the Commonwealth. Just as a first matter here, the issue of unfair surprise was something that was not raised below, nor was it raised in a counsel's brief. However, as that relates maybe to the standard in the way in which he did frame this issue, which was as newly discovered evidence, I will say that these medical records and even the medical opinion are certainly not categorized as newly discovered or newly available. As Your Honors mentioned, really, these could have been obtained with reasonable effort for use at trial. While trial counsel did assert on the morning of trial that she was unaware of any surgeries the victim claimed had taken place, she and the defendant were in fact both aware of the victim's injuries and the fact that he had received medical treatment as a result thereof. First of all, on the 911 call, he explains that he was injured. He says he thinks he needs an ambulance. And also, as Your Honors mentioned, it was actually on December 9th, 2015, which was about a year prior to trial, the Commonwealth moved under Rule 17 for the UMass Memorial Hospital records from August 7th, which are included in both my record appendix as well as the defendant's. And those actually discuss the plans for the first surgery. So counsel was on notice at least of the existence that these records existed, while she might not have been aware of the contents. And it's unfortunate, it does seem as if they did not make it to the clerk's file on the morning of trial. That does not discount or undercut the fact that defense counsel could have reasonably obtained these records. And for that matter, should she have wanted, she could have sought a urological expert such as Dr. O'Leary to interpret the records in time for trial, as civil counsel did months later in the civil action. Accordingly, the opinion and the records just cannot be considered newly discovered evidence, nor can they be considered an unfair surprise.
The defendant has not raised a claim of ineffective assistance, but it sounds to me as though lurking behind some of your criticisms here, that sort of claim might be lying in the weeds.
I don't think that's true, Your Honor, only because, well, first of all, I think that if we're looking at the second prong here of the newly discovered evidence standard, which is whether this evidence would have cast real doubt on the justice of the conviction, I think essentially that gets you to the second prong of Safarian as well. So in either event, the defendant wouldn't have been able to meet his burden here, given that, and I just want to clarify that in the defendant's motion for new trial, and when he submitted that at the district court level, all that was attached was this unsworn medical opinion purported to be written by this expert. It wasn't even accompanied by an affidavit from that expert. And it wasn't until I asked counsel, what were the underlying documents that this urological expert used in order to come to these conclusions that I was able to get all of the medical records, which there are many involved in that. And I was able to go through the records. And of course, I myself am not an expert, but just from looking at those medical records, it seems that that opinion is would have very thin support. And should counsel have called a live expert to testify, I certainly would have been able to cross-examine him on the conclusions within his report, which I just—
Let me just go back for a moment because, and forgive me, I should know this, but these medical records that you're describing, were those part of the record before the new trial motion judge?
Yes, they were. They were entered as an exhibit at the motion for new trial. And while the trial judge did use, I believe she used the opinion to determine that the defendant perhaps was entitled to an evidentiary hearing, and she did grant that evidentiary hearing, the defendant simply did not meet his burden in showing the credibility or veracity of that opinion because he didn't call any live witness to testify in support of that opinion, and therefore the judge just didn't credit it. And it was given no evidentiary weight, nor should it, and it just simply doesn't prove that the injuries that the victim testified to were not related to what the defendant had done. And the defendant has not done that with any evidence. He has not shown, and he certainly has not shown that the victim did in any way perjure himself. And really just a simple review of the records. And I also think that the opinion as it stands really mischaracterizes the records. If you look at that April 2014 record, it's pretty clear that while the victim did go to a physician for pain or swelling in his groin area, an ultrasound was run. And the results of that ultrasound were that the doctor found no inguinal hernias, which I believe that means groin, that there were no groin hernias bilaterally, which means both on either side, and that she did suggest a CT follow-up to get to the bottom of the swelling and the agitation that the victim was having. However, what that record really shows is that he had no hernias prior to the incident, or at least as of April 2014, which was about a month before the incident. And the records also show, based on the July 28th UMass Memorial records from the emergency department, that as of that time, which was about 2 months after the incident, that he was diagnosed with a hernia. So if nothing else, the records tend to corroborate the victim's testimony instead of undercut or impeach them in any way. And if we did have all these records at the time—
A temporal correlation does not establish causation, right?
That's true, Your Honor. I definitely agree with that, but I think that they would tend to at least corroborate, especially that the victim at least reasonably believed that the injuries that he had received for which he needed surgery were caused by the defendant based on this attack. And I note this in my brief as well, that it seems that he told a few doctors, this is why I'm having these issues. Somebody attacked me in a restaurant a couple months ago. And it doesn't seem, at least based on those records, that the doctors ever corrected him and said, well, that doesn't make sense. That's not how you get a hernia.
I'm sorry, Attorney Russell, we seem to have lost Attorney Curhan momentarily. Why don't we pause the argument, Attorney Curhan, while you disappeared momentarily? Okay, go ahead, Attorney Russell.
I would just encourage this panel to take a look at the excerpts that I provided in the supplemental record appendix with respect to those. There's really 3 dates of records that I think are really pertinent here that show that the Commonwealth probably would have even sought to admit these records ourselves, because they corroborated the testimony of the victim, that he reasonably believed that these injuries that he had were a result of what the defendant had done. And they certainly, I think they actually undermine the opinion, which again should not be credited at all, as the motion judge, who was also the trial judge, did not credit them when she denied the defendant's motion for new trial on the basis of not having sufficiently presented evidence, newly discovered evidence that would cast real doubt on the justice of the conviction. And if there are no further questions, or if your honors do not want to get into the second issue.
Actually, counsel, I did have a question on the second issue. So putting aside for the moment that that defense counsel may have opened the door, let's assume that that testimony had not come out on direct examination. Would you agree that it would have been improper for the Commonwealth to ask the defendant about his failure to go to the police?
No, because I do think that obviously the case law, it's pretty well settled that the Commonwealth may impeach a defendant with respect, with the fact that he had an opportunity but failed to tell the police.
No, we're assuming that it had not, there's no testimony, he was not asked on direct examination why he didn't, whether he went to the police and why he didn't.
Right.
So what is there then to impeach?
Well, I think just the fact that somebody had that a defendant who's subject to cross-examination and has given up his right to self-incrimination, that the Commonwealth may on cross-examination essentially impeach their story, their version of events with why didn't you
Would have been
natural in the circumstances.
Would have been natural. So here you have two guys involved in a scuffle in a Burger King, if you believe the defendant's version. And then they go their separate ways. Why would it have been natural for him to call the police?
Well, given the defendant's testimony, he said that the victim essentially had attacked him without provocation. And the defendant himself, he stated he had plenty of medical issues and he was not the healthiest person and he was being attacked by this stranger. He actually, given his own testimony itself, he said he pleaded with the employees at Burger King to call someone. And you know, he testified that for no reason, this man had elbowed him, kicked him, hit him 3 times while he simply.
How do you distinguish Nemec, which was cited in the defendant's brief, where the defendant stabbed the victim and then later claimed it was self-defense, and the court said it would not have been natural for him to call the police to tell his side of the story, that it was
right. I think that in Nemec, I think a defendant is under no obligation to contact the police and tell them their own exculpatory version of what happened. But this isn't that situation. I don't think that the defendant should have called the police to say, listen, this guy's going to say that I attacked him. I just want you to know that it was self-defense. I think especially as an attorney himself, he knows that this was an unprovoked assault and battery. Why would he not go to
mean he'd call the police?
I'm sorry.
Why does that mean he would call the police?
I think
not everyone who's a victim of assault and battery thinks it's a wise idea to call the police. Because you may start something that will result in a counter complaint. And for an attorney, there might be every reason in the world just to let it go.
I think that's right, Your Honor. And I do think here that a very important issue, and I know Justice Shin asked me to put it aside for a moment, but I do think that it is very important in this case that the defendant did bring this up on direct examination.
That's a separate issue.
So going to that issue, so he is asked, did you call the police? And the defendant says, no. Why not? I was done with it.
Right.
So why does it make it any more admissible, permissible for the Commonwealth to question about it? And what exactly is being impeached here?
Well, essentially, he opened the door to this line of testimony. And in fact, defense counsel used it in her closing. She said, you know, he didn't even call the police because it wasn't a big deal. And that's exactly what she got out on direct testimony. It seems as if she wanted to get out on direct testimony because she asked him that. And then she used that.
And I mean, so I feel like this is a little bit circular, but if in fact it would not have been natural for him to call the police, I don't see how her asking those questions made it permissible for the Commonwealth to then ask him the questions that it did.
Well, I think that counsel opened the door, and I would ask Your Honors to take a look at Commonwealth v. Johnson, which I cite in my brief, 46 Mass App Court 398, that has to do with identification procedures where, you know, during the motion in limine phase, counsel talks about not bringing up the fact that defendant had refused to participate in an ID, and Commonwealth agreed to that. However, the court said, you know, unless defendant opens the door to it, you know, Commonwealth, you can't talk about this. And essentially the defense counsel on direct examination of the defendant, who had given up his right to self-incrimination and was cross-examined, counsel opened up the door by asking him essentially, questions to the effect of anything that he had done to essentially avoid anyone picking him out in a lineup, or I think it was a voice identification. And the judge found that because she had asked those questions, she had opened the door to the Commonwealth to be able to ask, well, isn't it true that you refused on 2 prior occasions to even do the identification procedure? And that was found to be proper line of questioning because, again, defendant had opened the door to it. And for that reason, I think that it was proper here. I'd also note that the Commonwealth did not bring this up again in closing. And I'd also note that defense counsel did not object to this. When the Commonwealth started asking these questions, this would not be a preserved issue. I think in her affidavit attached to the motion for new trial, she says, you know, I heard the Commonwealth asking these questions and I was uncomfortable, but I didn't object. Well, that doesn't mean that it gets preserved just because she thought that it would draw attention to the jury, unwanted attention. And she also states that she asked for a curative instruction, and that's just not in the record. There are a few inaudible sidebars. However, the defendant never moved to reconstruct the record, as would be his burden under Mass Rule of Appellate Procedure Rule 8. So I just don't think that the defendant has met his burden here to show that that was any sort of trial error that would entitle him to a motion for new trial. And for those reasons, if there are no further questions, the Commonwealth would rest on its brief.
Thank you both. The case is.
I'm ready.
Well, I'll call the case when we're live.
Thank you, Judge.
If you have another device on, please mute it.
I am. Sorry about that.
And we are back live and on the record.
Okay, the next case on our list for hearing this morning is case number 2020 P546, the Commonwealth versus Christopher L. GOPAUL. Mr. Bassoni.
Good morning, Your Honor. Please court Joseph Vassone for Mr. GOPAUL. I have 4 issues that I would like the court to consider today. Just as a preliminary matter, Judge, on the 4th issue that I raised about the assault and battery being a lesser included offense of armed assault with intent to murder, the Commonwealth was correct in that the lesser included offense was given not state prison time, but house of correction time. So I would agree that that sentence, that house sentence, which ran concurrent, should be vacated. Other than that, I would stand on that particular argument because.
Well, while we're on that topic, you would also, the Commonwealth goes on to say that because of that, in addition to vacating that portion of the sentence, there is no need to remand for resentencing.
Correct. If you vacate it, it's
okay.
Vacated, it's gone.
Yeah. Okay.
Yes. That being said, Judge, I would start obviously with my first argument. Here we have a situation where we have an immunized witness, and the question for the court is, was there sufficient corroboration of her testimony to satisfy the statute? And my argument was that it was not, notwithstanding the fact, I might add, that there were 2 videos, one video of the actual scene of the crime, the outside of the building, where an individual was seen walking around with a long object and a blanket, and the other video, which was a video of Sewell Street, where the motor vehicle was. I say that because my understanding, Judge, again, of the case law is that the corroboration has to be to a specific element of the crime. And I don't see what those videos would contribute to satisfying that requirement, that the testimony of the immunized witness was corroborated by evidence of a specific element of the crime. That being the case, we have the testimony of Ms. Williams and the liquor store owner, Mr. Nunez. As I argued in my brief, there was no, and this is actually going into argument 2, but it's pertinent to argument 1. I don't believe that the testimony of Ms. Williams corroborated the testimony of the immunized witness, in that there was no identification of the defendant at the scene.
Well, is corroboration of identity required?
Well, no, Judge, but maybe I'm getting a little ahead of myself. When she testified, her testimony at trial was she was shown a map of the area. And she said, I saw the defendant right here. So she said, the defendant. Now, as I said in my brief, when you take, I'm taking that as an identification of Mr. GOPAUL as the defendant. I mean, I don't think you could take it any other way. And because you take that statement, the defendant was standing right here, and you join that with her statement to the police and trial testimony that he said, I just shot someone, okay? You now have an admission of a party opponent, which is not, it can't be objected to in terms of the hearsay rule. So that stays in. And so the only way, in my view, around that is to say that
And we are back live and back.
Please continue.
Thank you, Your Honor. Again, as I was saying, we have the testimony of Trina Williams, who says she saw someone who looked like the defendant at the Walgreens. And she never, and this is getting into the next argument, she never testified that she identified the defendant at the scene to the police officer. And as I argued in the brief, all we have is her in-court testimony that this is where the defendant was standing, as she points to a map that was provided to her by the Commonwealth. And as I argued in my brief, I don't think that that is a sufficient identification. I think it's a suggestive identification, because clearly the only individual that's in the courtroom that would match up in terms of the defendant, that would be the gentleman that's sitting next to defense counsel. And that being the case, and defense counsel and Mr. GOPAUL do not look anything alike, different races. So there's no way that she could confuse the lawyer with the client. And so for that reason, as I stated in the brief, Your Honors, I believe it was a suggestive identification.
Was there an objection or a motion to strike?
No, Judge, there was not.
All right, so if we were to agree with you and we were looking at this under substantial risk review, is the difference between I saw the defendant and I saw a man similar to the defendant in description or answering to the description of the defendant, or who looked like such and such, is that distinction enough to create a substantial risk of a miscarriage of justice?
Well, arguably, Judge, I would say it is, because she's in the courtroom, and again, she never identified the gentleman at the scene as being the defendant. There was a show-up identification conducted by, I believe it was Officer O'Malley, with Mr. Nunez, who was the liquor store owner, and he definitely identified Mr. GOPAUL, and I believe at trial counsel conceded that was in fact him, but that does not necessarily mean that that just because he was the individual at the liquor store, that he was also the individual that Ms. Williams saw as she was going from her apartment over to the Walgreens.
Didn't the testimony of the immunized witness fairly clearly establish his identity as the perpetrator?
Well, that's another problem, Judge, because again, she never left according to her testimony, she never left the car. Two people went into the building, Mr. Smith's apartment, Mr. Smith being the victim. And there were two individuals that went into the building, according to Mr. Smith, who, again, he couldn't identify either individual as to which one was, as to who was who, and nor could he identify them, period. And so the question is, did the Commonwealth present sufficient evidence of a joint venture so that you could say, well, it doesn't matter which guy pulled the trigger because they're both guilty, because of a joint venture theory? There was no evidence of that. And so all we have is two individuals who nobody knows who they were.
Yes, I mean, again, I realize that your contention is that the immunized witness's testimony ought not to count in the balance. But there was certainly a great deal of information in her testimony that went to motive and identity and involvement. we were interrupted before. I interrupted us before by my internet disruption, but identity itself is not required to be corroborated. We do have some corroboration of identity as well, but you're challenging that corroboration, but it doesn't matter, right?
Well, the identity doesn't matter, but I mean, the entire testimony of the immunized witness is up for, an assessment of her credibility. And
Right.
that's how you get the corroboration under the.
But there were other aspects, material aspects of her testimony that were in fact corroborated. And her testimony, having been corroborated, provides a great deal of support for the identity and involvement of the defendant.
Well, again, respectfully, Judge, I failed to see where the other corroboration came from. If the court is thinking about those videos, again, those videos just show basically silhouettes of individuals.
I mean, at a baseline,
yes, Judge.
There are cases that say that the corroboration can be as simple as the fact that the crime occurred.
That's correct, and I think I cited that in the brief. But again, the crime occurred, but we don't have any indication as to exactly who committed it, other than her. But I do agree
but the point is that her identification of the defendant as the perpetrator of the crime does not itself have to be corroborated.
That's correct.
So having corroborated her testimony by the fact that the crime occurred, the jury may consider her testimony pointing to the defendant as the perpetrator, right?
I would concede that, yes.
Okay.
Counsel, could I ask you to clarify something in the record? In your brief, you claim that Nunez's in-court identification should not have been admitted. I didn't see him make an in-court identification anywhere in the transcript. Did I miss it? Or are you challenging the show up and not an in-court identification?
I was actually challenging the show up because I believe the police officer testified that he did a show up and that Mr. Nunez pointed to Mr. GOPAUL as the person who robbed or committed larceny, I should say.
And there was no motion to suppress filed, right? To suppress this identification?
I do not believe there was, Judge, by defense counsel.
Thank you.
That being the case, if there aren't any other questions, again, issue 4, I think that's already been covered about the lesser included offense. So if there are no other questions by the panel, then I would submit on my brief, and thank you very much.
Thank you. And again, I'm sorry for the disruption. Nice recovery.
No problem. Thank you, Your Honor.
Mr. Charles, the Commonwealth.
Thank you. Good morning, Your Honors, and may it please the court. Assistant District Attorney Jamie Michael Charles from Middlesex on behalf of the Commonwealth. As the Chief Justice alluded to during my brother's argument, in order to corroborate the testimony of the immunized witness, the Commonwealth was not required to establish the identity of the defendant as the perpetrator. The Fernandez case, which the Commonwealth cited in its brief, pretty squarely addressed the earlier Dabrowski case from the SJC and declined to alter that rule to require corroboration of identity. And if you look at the Dabrowski case, which the Commonwealth also cites, in discussing the origins of Section 20I's requirement that there be some corroboration, the court looked to the earlier case law regarding testimony of accomplices who aren't immunized, and the fact that the testimony of a non-immunized accomplice standing alone without any corroboration could suffice. And the court divined from that that the degree of corroboration necessary where someone is immunized is not such that you need to establish every element of the crime, or even that you have to have, proof beyond a reasonable doubt of specific facts. It's just there needs to be some evidence that suggests that what the immunized witness is saying is truthful and not a complete fabrication. And here, I think, as the Commonwealth attempted to explain in its brief, there was a variety of evidence, not only that the crime occurred. I think the evidence of the crime occurring itself, as you can see in the Resende case, which the Commonwealth also cites, in that case, the immunized witness basically gave testimony akin to what Ms. Garland testified to in this case, that he was part and parcel to a plot to commit a crime. In that case, it was, I believe, a armed robbery for drugs, that he met with the defendant and others beforehand, that he drove 90% of the way to the scene, but stopped short of the scene while the defendant continued on in another car with other people, that he then saw the defendant fleeing in the car several minutes later, and that the next day he had a conversation with the defendant in which the defendant made statements alluding to having shot someone. That's essentially what we have here. Ms. Garland was privy to the defendant's dispute with Mr. Casito, or at least the aftermath of that pistol whipping where he had an injury to his head. She heard the defendant make numerous statements that he was going to Casito's house. They stopped at Mr. Human's house to pick up a shotgun wrapped in a blanket and then proceeded to Framingham to Sewell Street in the vicinity of Phelps Road. The defendant with the other passenger, who was identified as Smokey, exited the car and went into a wooded area that the testimony was provided access to Phelps Road. There was surveillance footage showing an individual who inferentially was the defendant holding a item wrapped in a sheet, wearing camouflage pants, which were testified by the immunized witness as what the defendant was wearing. That individual removed the sheet from the gun on the surveillance footage. A sheet was found in the area which the individual on the surveillance footage passed through. And then there was testimony from Mr. Smith and his neighbor and police that established that a break-in and a shooting occurred. There was evidence of shotgun shells. There was evidence of shotgun discharge on the wall of the house. Mr. Smith had injuries consistent with being shot with birdshot. The neighbor testified to hearing 2 shots. And then there's surveillance footage from Sewell Street showing 2 individuals get back in the car that the immunized witness testified was her and drive away around the same time that the shooting occurred. So I think there was ample evidence just standing alone from the fact that the crime occurred and the surveillance footage, not even getting to the additional information from the Marlboro crimes, which the defendant's counsel conceded in both opening and closing argument that the defendant did in fact commit. So it's, I think my brother is, he seems to have conceded an oral argument that proof of identity is not required, but I think he was sort of holding the Commonwealth to a higher standard than the law requires in his brief. And I believe that the Commonwealth amply established both the defendant's identity and the material particulars of the crime occurring itself. As for the testimony of, of Ms. Williams, while I do concede that it was most likely improper for there to be a reference to the defendant, I have to point out, as I did in my brief, that this was not a question or an answer that was solicited by the Commonwealth. The Commonwealth was merely asking the witness to point her location out on a map. The Commonwealth never referenced the defendant in its questioning. As the court noted, the defendant did not object. Neither the judge nor the Commonwealth brought any attention to the fact that the statement had been made. That was the only time the witness referenced, quote unquote, the defendant. And as I argued in my brief, I think even assuming you find that this was error, I don't believe it amounts to a formal in-court identification, but certainly the argument can be made that it's better left unsaid. It's reviewed under a substantial risk standard. And I think there was ample evidence here from Officer O'Malley's testimony, from the description of the suspect and how that description related to the individual on video and identified by Mr. Nunez and Capital Liquors, that this was clearly the defendant who was traversing from the Capital Liquors where he had stolen the bottle of scotch to the Walgreens, which was in the direction that Ms. Williams pointed the individual where he was apprehended minutes later. So I don't think this materially prejudiced the defendant, certainly not to the point that it created a substantial risk. And as to Mr. Nunez's identification, well, I don't think it was unnecessarily suggestive. I don't even really think it matters because the defendant, again, admitted that he committed the liquor store robbery. So he couldn't have possibly been prejudiced by the store clerk identifying him as the culprit where he himself conceded that to be the case. So unless, and obviously the Commonwealth concedes as to the remaining issue that assault and battery is not a lesser included offense and that house sentence would need to be vacated. So if there are no further questions, the Commonwealth will be content to rest on its brief and ask that you affirm Mr. GOPAUL's convictions beyond the assault and battery.
Seeing none.
Which begins with, at the bottom, it recites the language of the revision agreement for the terms of the note, which was recorded, and which begins with, at the bottom, it recites the, I beg your pardon, I'm pausing a little bit because I'm hearing myself echo, and that happened the first time I participated in a hearing. And so I'll just soldier on through it.
Do you have another device with the YouTube live stream?
Because I'm hearing myself echo, and that happened the first time I participated in a hearing. So I just closed out through it. all browsers,
Another device,
and it's
the YouTube live stream, because I'm hearing myself echo, and that happened the first time. If you were watching the YouTube live stream previously, it's possible that there's a slight lag between the live stream and the Zoom argument, and you need to mute that other sound feed.
okay, Justice, thank you. What I did was close out the browser, and
Okay.
I think that solved the problem. Sorry about that.
Please continue.
Okay, on page 9 is the revision, at the bottom is the language that I point to in the revision agreement between Ms. McMath and Mr. SHEA. And what it says in bold is, the note is hereby further amended as follows. The maturity date referred to in paragraph 3 of said note is hereby changed to September 15, 2008. On page 11, I point to the language in the revision agreement between the bank and Overlook, and it says, and I've bolded it, the note, mortgage, and any and all other agreements, instruments, or other documents and other language are hereby amended. And then the language says the note is herewith amended to change the maturity date. So the difference that the lower court here pointed to distinguish the revision agreement in our case here, in the instant case, and in Overlook, is that the mortgage was explicitly referred to as being one of the documents amended.
Well, Mr. Kia, let me just take you back. Let's step aside for a moment from the revision agreement and look to the original note, which of course had a maturity date even earlier than the note as amended by the revised agreement, by the revision agreement. Correct?
Correct.
Okay. If you had recorded an affidavit attaching the original note, if you'd recorded that in the Registry of Deeds, how would that differ from the circumstances where we now find ourselves?
It would be a recording of the original note and not a modification. But
the modification, as you've already alluded to, modified only the note, not the mortgage, right?
Correct, Your Honor.
Okay, so your argument necessarily requires a conclusion that a mortgage that refers to the note as the obligation it secures incorporates as a term of the mortgage the maturity date of the note and is therefore subject to the obsolete mortgage statute if the note is placed of record. That's not my understanding of the law, but that's my understanding of your argument.
I did anticipate that question, Chief Justice.
I'm sure you did.
The answer is I don't know. I don't know what happens if the note is recorded. All I know is that we have case law in Overlook that dealt with a modification agreement, and what would be to happen with the application of the obsolete mortgage statute. I don't know the answer to that.
Well, an Overlook, of course, is an unpublished decision. So setting aside the question of whether it's certainly not binding, whether it's persuasive is a separate question. But we've got a fairly rich history of case law and statutory law that deals with the nature of a mortgage. Eaton represented a fairly significant departure from prior law, which it recognized as a departure in saying that it would apply prospectively only. But the note and mortgage always have been separate instruments. And the obsolete mortgage statute was designed to address a quite different set of circumstances than what we have here. I mean, as I understand the sequence of events, you recorded the revision agreement during the midst of proceedings to enforce the mortgage. It's nice work if you can get it, I suppose, to post hoc render a mortgage invalid by placing the note on record, but that's not my understanding of the way the statute works or the way that the mortgage is.
The proceedings you're referring to, Chief Justice, was the service members case.
Right. But the point is that that service members case was judicial proceedings. It's the only judicial proceeding in a statutory power of sale, excuse me, state. But it was clear at that point that the note holder, mortgagee, was taking steps to enforce the security obligation under the mortgage, right?
Correct.
And placing the note of record was your effort to basically thwart that enforcement.
My client had the right to record something that affected title to our property.
Well, I understand that, but the question of what the note does not affect the title. The mortgage affects the title, and the mortgage was not affected by the revision agreement.
The argument that I present is that it did because of the rationale in Overlook. And I point to page 15 of my brief, Chief Justice, and the lower court, the land court, same court in Overlook, addressed the argument of the plaintiff in that case. And the plaintiff specifically points to the language contained in the modification stating the note is herewith amended. And what's interesting is the plaintiff here did not point to the language of the mortgage being amended that were in those modification agreements. And the court goes on to say, plaintiff alleges this language served only to modify the maturity dates of the 1987 and 1989 notes and not the mortgages. Had the parties intended to modify the mortgages or any other loan documents, plaintiff argues they would have specifically included the word mortgage in the above provision. And then on the next page of the brief, the court says, this court is unconvinced that the maturity dates can be so easily distinguished for purposes of the obsolete mortgage statute in light of the SJC's decision in Deutsche Bank versus Fitchburg Capital. So the argument in Overlook was made that it was only intended that the note be modified and not the mortgage. And that is the same argument Mr. SHEA made here. And in Overlook, the court rejected that, basically saying that it was a form over substance argument. So that's the argument I present to the court. And I know the court may disagree with me, but it's the facts of this case, the facts of the what was contained in the modification agreements are almost identical. And the lower court here is distinguishing and saying that because it wasn't specifically said that the mortgage was modified, that the modification agreement doesn't have the effect of bringing within the four corners of the mortgage instrument maturity date of the revised maturity date of the note.
Isn't the key difference between this and Overlook that in Overlook, the recorded notes, the recorded modification agreements specifically amended both the note and the mortgage?
That is the key distinction that the lower court here, that Judge Vahey and land court here made. Yes,
well,
Justice
the distinction that could in fact matter. First of all, and second of all, I return to the question I opened with, because the revision agreement modified only the note. The circumstance we have here is literally no different than if you had recorded the original note, which also had an even earlier maturity date.
I suppose
the original note had never been modified.
If the original note had never been modified, I don't know. I suppose
it's the identical situation. If you had a stated maturity date in the note of 1 year, never modified, and you slap an affidavit on the record with a copy of the note, it's the same situation as what we have here.
And to that, I would respond, Chief Justice Green, is in the Overlook case, if maybe the circumstances in that case would be identical if the bank chose to record the notes instead of the modification agreements.
Let me ask the question more generally. What, in your view, is the intent of the obsolete mortgage statute, and how would allowing recordation of the note or the modification to the note, either one. But in particular, after the precursors to foreclosure proceedings have begun, how would that satisfy the purpose of the statute? Or how does that fit within the purposes of the statute?
The purpose of the obsolete mortgage statute was to solve the problem of mortgages being paid off or somehow disposed of, strike that, the underlying obligation secured by the mortgage where, for whatever inadvertent reason, the mortgages weren't discharged. And so it provided a solution, a legislative solution to that problem of companies going out of business, titles being in question because mortgages weren't discharged. So the standard mortgage term is 30 years. So,
right. That's pretty narrow, though. That's called, we all rely on the registry to understand whether or not these mortgages have been discharged, and folks have bellied up and they can't discharge these mortgages anymore, so we're going to fix it.
Right.
How do we get from that to a mortgage which has no term on its face is transformed into a mortgage with a term by virtue of a note, be it recorded or unrecorded? How do we get there from the purpose of the obsolete mortgage statute?
I guess that would open the door to everybody recording notes in hopes that they would be able to utilize the statute as a.
But that does not, you're not answering, that's the effect of what that would do. But the question is, how does that align with the purpose of the statute?
How does recording the revision agreement align with the purpose of the statute?
Yeah,
right.
No. How does creating a circumstance where a borrower can transform the note of the mortgage from a mortgage without a stated term into a mortgage with a stated term align with the purpose of the obsolete mortgage statute, the purpose that the legislature had in mind?
I don't know the answer to that question because none of the case law nor the statute itself addresses whether or not the application of the law is effective depending on who records it.
So what? Go ahead.
I finished my thought, Justice Sullivan.
All right. I'm just, this is your world. And so I want you to have the opportunity to say what you think the impact would be of opening the door to allowing notes as well as mortgages to be recorded, for good or for ill. As a policy matter, what do you think the impact of that would be?
It would, well, on the one hand, it might have an undesirable effect of everybody finding the loophole in the law and finding that if they had a modification agreement and there was a maturity date of a mortgage that was 30 years from now, and then the modification agreement, strike that. If a mortgage did not have a stated maturity date and somebody had documents that govern the maturity date of the underlying note, then certainly people are going to try and take advantage of that and record it. But it would also have the positive effect of financial institutions and private lenders making sure their paperwork is in order and putting maturity dates on mortgages.
Thank you, Mr. Kia. Attorney Gelano. You're on mute, Mr. Attorney Gelano.
Sorry about that. Good morning, Justices, Chief Justice Green, Justice Sullivan, and Justice Shin. I'm here on behalf of James SHEA, the appellee. It's clear to me that the court has read the briefs, and I would like to just address what the court has been asking of Attorney Kaya, that perhaps would be the most direct way to start. The purposes of the obsolete mortgage statute would not be enhanced by borrowers being able to do what's been done here, to record a note, or in this case, a revision of a note. Essentially, I think they're the same, where the note itself and the revision agreement do not purport to change the terms of the mortgage. And Deutsche Bank, which is settled law from the SJC, talks about how to best carry out the intent of the obsolete mortgage statute. And the court stated that this intent is best carried out when term and maturity date are read as the duration set forth in the mortgage instrument. The mortgage is recorded in the registry of deeds. The note that the mortgage secures is not. Thus, the note may be satisfied, lost, or changed without notice to the public, unlike the notice to the public that the mortgage provides through its recording. There's a citation. By basing the discharge date on the term or maturity date included in the mortgage instrument, the legislature has ensured that the enforcement period of mortgage is clear from the record, allowing for more efficient discharge of obsolete mortgages.
And do you read that to mean clear from the record, not even as to non-third parties, even as to the parties to the transaction who all know what the deal is with the note? I understand that quote with respect to third parties. Why is that kind of clarity in terms of recording required by the obsolete mortgage statute? What evil does that address as between the parties to the note and the parties to the mortgage?
Well, I guess I would answer that by saying that the obsolete mortgage statute doesn't address the relationship between the parties. It really addresses the public recording of the mortgage, and whatever has or has not gone on between the parties doesn't have an impact on what's on record at the registry of deeds. That's precisely why the obsolete mortgage statute, I think, was amended to deal with the problem. And it's discussed in the cases and in this decision, and it's a common problem in lending, that there are notes that are paid off, but the mortgages are not, but the mortgage is not discharged. And this was a way, and the decisions written in all of these cases that are referenced in both briefs draw the distinction between what's on record. And if there were some other understanding between the parties, I don't think that changes what the law should be with regard to interpreting the obsolete mortgage statute.
So you're saying the purpose of the statute is so narrow that in fact this is not dependent, as it might be in other circumstances, on whether or not a third party good faith purchaser is involved. This is just a narrow statute, narrowly drawn, and requires recording. Is that the argument?
Well, it requires recording of a mortgage that both parties are party to. And this is perhaps hopefully responsive to your question. Mr. SHEA purposely entered into an agreement with a mortgage that did not have a stated maturity date, which allowed him to be protected by the obsolete mortgage statute as written and interpreted, that says that he has 35 years from the time of recording in order to enforce the mortgage, which is, of course, is a different remedy than the note itself. And that's been discussed as well in many of these cases. what Ms. MCMATH has done here is to try to unilaterally change the contract between the parties by recording a note that she claims changes the mortgage, but the cases are clear that unless the mortgage states a maturity date or specifically references the note and states in the mortgage the maturity date of the note, the 35-year portion of the statute is the one that the lender can look to in order to preserve the lender's rights to foreclose. I hope that's responsive.
It is.
I think that the decision by the lower court is supported by the reasoning in Deutsche Bank, both at the land court level and at the SJC. And I think it also reflects the public policy that Deutsche Bank speaks to about how the obsolete mortgage statute should be interpreted. And unless there are further questions, I would rely on the brief that was submitted on behalf of Mr. Shea.
Thank you very much. Thank you both. The case is submitted.
Thank you very much.
Morning, Your Honor. It's a pleasure.
Wait, Mr. Nguyen, wait until we call the case.
And we are back live and on the record.
Okay, the next case on our list for hearing, now it is this afternoon, is case number 2019 P1654, Ann M. Foley and another versus Charles R. TEVNAN. You may begin.
Jeff Wynn for Ms. Foley. It's a pleasure to be before the court again. The question before the court involves a transaction between Ms. Foley and her attorney, which is subject to careful scrutiny before determining that there was no overreaching of the client and no abuse of confidence. In this transaction, it involves a trust formation that was drafted by the attorney to allocate himself 1/4 interest in trust himself for alleged legal services and imposes a fiduciary duty upon the client to count and maximize funds to his benefit. Must be reviewed carefully to determine whether it's violative of public policy. So the two policy question is whether it's permissive to convert your client into your fiduciary as you undertake to perform legal services for her. And the second is whether a conveyancing attorney who was hired to purchase a property ends up owning a stake in that property. Those questions need to be reviewed a bit carefully, because I can imagine a circumstance where attorneys who practice conveyancing encounters unwittingly client who wasn't the all wherewithal and agrees to allocate a percentage of a property, no matter how much consideration you may impose upon it. In this case, the attorney is claiming $40,000 to $50,000 worth of legal services that allocates himself a 25% interest in a commercial real estate. And
Mr. Nguyen, this case was tried before a judge who entered written findings of fact. Are you challenging any of those findings as clearly erroneous?
I believe the court's findings is inconsistent. It's erroneous, but it's also inconsistent. The court's finding the purpose of the trust is to purchase real estate for Ms. Foley and to move her business into. But at the same time, it runs contrary to the ultimate outcome of the case, which is Ms. Foley.
I'm talking, first of all, I want to establish a baseline of the question of the factual findings on which the ultimate conclusions rest. Are you challenging the accuracy of any of the individual findings of fact that the judge entered?
I am. We're challenging the fact that she was one who proposed that they enter into a trust relationship in which she owes a fiduciary duty to her attorney.
Okay, and you're challenging that as on the your burden, of course, is to establish that finding is clearly erroneous, meaning that it is not supported by any evidence in the trial record.
It is not. If we're reading that the trust itself, then of course we would establish that is evidence that she entered into this agreement.
Well, there was testimony as well, right?
There is testimony as well.
Okay, and it's the prerogative of the judge as finder of fact to determine which testimony to credit and which testimony to disbelieve, correct?
That is partially as well, but the inference that's drawn from his finding that the purpose of the trust, which was to buy real estate for her and move her business into, runs contrary to the fact is that she understood that he owned an interest in the property, meaning he has control over the property.
Okay, now the judge also made a finding of fact that the attorney advised the client to consult independent counsel and that the client determined not to do so. Is that correct?
Yes, Your Honor, and that is one of the factual findings that again that's how the judge would view the circumstances.
Was there testimony to support that finding?
There was testimony to support that finding.
Okay, but do you contend, despite the presence of record evidence to support that finding, do you contend that the finding is clearly erroneous?
It's not as clear erroneous, but that itself, of whether a client is advised to seek independent counsel or not, doesn't waive the question as to whether the transaction as a whole is fair.
I understand that. I'm just trying to establish what our baseline is in terms of the factual foundation on which the ultimate questions of law rest.
Yes, Your Honor.
Okay, so what we have is a finding that the client was sophisticated, was fully informed, and made a voluntary waiver of the right to or the option to seek independent counsel, and that the trust was formed for the purpose of acquiring title to this property.
The question that I need there's no factual finding as to the conclusion she's a sophisticated, savvy businesswoman. The only testimony as to her prior history as an insurance agent was through her. There was no other evidence indicating her business acuities or her intelligence. She was a high school educated individual who had been doing customer service throughout her time in the insurance agency and decided to go about becoming an insurance agent. There's no other evidence aside from her own testimony about her ability that he could conclude such a finding. And that itself is clearly erroneous. We're focusing on we're utilizing a judgment of a person's intelligence to determine whether this transaction is fair. But there's no evidence aside from her testimony as to how smart or unintelligent she is. So that is clearly erroneous. The finding that bases the whole case upon is that she's savvy businesswoman. And so where I'm asking the court, and Ms. Foley's asking the court, is to set this transaction aside or issue a constructive trust over this property. If we look at the transaction, it does not show intelligent, savvy businesswoman, but one who was dependent upon her attorney. And her attorney decided to form this transaction in the middle of a closing to purchase a note and mortgage. These are indicias of undue influence that the attorney has over a client. It didn't occur afterwards. It occurred at that time. And so that's what we're looking at. We have to carefully review whether whether that relationship has been mitigated by some review by another attorney, or the transaction itself is fair. But again, it focused straight back on the question as to whether Ms. Foley understood she lost control over her property. She, as a trustee of a nominee trust, by its very nature, indicates that the trustee has no power, but she wanted to be a trustee. To me, it demonstrates she doesn't understand the trust instrument. It demonstrates to me that she believes as long as she has title to the property that she has control. That is not the case in this circumstance. She became a tenant in common the day she signed that instrument. And the power that comes with tenant in common is to be able to terminate that building at any time and petition and sell it. That cannot be what she wished for when she hired this attorney to buy the property for her. That is the fairness that I'm struggling to deal with. How an attorney can be retained to purchase a property, but at the same time have the power to eliminate it. And I'll rest my remaining arguments on my brief.
Thank you. Attorney Gianos, you're going to need to unmute yourself.
I apologize, Your Honor. May it please the court, Kiri Giannoulis for the appellee Charles R. TEVNAN. As an initial matter, and the Chief Justice was delving into this on if my brother was attacking the findings of fact, I just want to correct the record here that Judge Ullman's findings, which are contained in the addendum at paragraph 8, he writes, Ms. Foley was an intelligent, competent, savvy business person, having created and run an insurance agency for 18 years. I believe my brother stated something a little different. She had owned an agency for 18 years at that time. The record shows that she had been a trustee of a prior trust, that she had owned other commercial buildings at that time, that she was approximately 58 years old. So the argument to attack the trial court facts, first are facts in the record on which Judge Ullman relied, and it's the burden of the appellant and the moving party attacking these facts to point to some other evidence in the record. Clearly, a thorough review of the record shows that Judge Ullman, who spent 4 full days, reviewed hundreds of exhibits, and listened to a lot of testimony from Miss Foley herself, 4 or 5 hours, found her sophisticated. And I think Judge Ullman used the word sophisticated because in the line of cases which really dominate this case, the Pollack versus Marshall cases, cases in which a lawyer and a client enter into a business transaction, and there are also ethical rules governing that. The sophistication of the client is important. I'd use another word. It's not intelligence, it's what that client knew at that time. So the essence of this case is, did the trial judge, after hearing all the evidence, find that first, Charles R. TEVNAN, an attorney at that time about 10 years, he's now a 30-year attorney, did he at that time perform the duty he said he was doing? Did he do the legal work, which consisted of, and I won't run through it because it's fully briefed, consisted of hundreds of hours of work. This was a commercial property, had environmental problems, had bankruptcy issues attached to it, the prior owner. He had to run many different issues down. Trial judge listened to 2 hours testimony from Mr. TEVNAN concerning this. There was no expert testimony from the other side attacking that this legal work was either should not have been done, there was overbilling, there was any type of legal work that wasn't done properly. There was trial testimony below concerning the environmental analysis, and the trial testimony of the plaintiff here, Ms. Foley, pretty much mirrored what Mr. TEVNAN said he did in his work. So the first part of the analysis, did Mr. TEVNAN do the work he said he did? The judge found he did. Judge then moved on to the trust relationship. I won't go through the whole story as it's fully briefed in the statement of facts of why a trust created. It was done because Ms. Foley wanted a straw because of the prior owner of the property being a friend, and she didn't want this Mr. Sika knowing that she now bought the property. But the trust was created. The trust, as the trial record shows and the findings of fact, was reviewed with Ms. Foley, who at this time had owned an insurance agency for 18 years and was a successful businesswoman, and had been the trustee of a prior trust. Reviewed with Ms. Foley, another attorney, Attorney Cullen, who became the original trustee, so that this Mr. Sika would not know Ms. Foley was behind this. He said under oath at trial that he reviewed it. He reviewed the complete nominee trust, what was going on, what the beneficent interests were. Okay. Prior to that, which is December of 98, when Mr. TEVNAN had given his bill to Ms. Foley, she informed him that she couldn't pay him. The bill was approximately $40,000, which the judge finds in his findings. Ms. Foley is the one who offered the equitable interest in this, we'll call it business transaction. So Judge Ullman was totally on point, totally correct at finding first, did Mr. TEVNAN do the work? Second, was it fair and reasonable, the business transaction? Third, was it explained to the client? And four, did the client understand it? And five, and here's a little issue with, does the disclosure have to be in writing or not? There was an actual trust document which would explain the entire business transaction, which Ms. Foley admits executing at that time. So applying the Pollack versus Marshall standard of entering into a business transaction with a client, the trial judge found, as can be seen in the rulings of law, that Mr. TEVNAN had fulfilled all the elements to avoid any type of fiduciary duty action. What's important in this case too is, and as this court well knows, in a breach of fiduciary duty case, the burden shifts to the defendant. So Ms. Foley didn't have to prove that Mr. TEVNAN breaches fiduciary duty. Mr. TEVNAN had to prove that he didn't. So he had the preponderance. So that's even a higher standard that the Judge Ullman found he rightfully overcame. So as to the real essence of the case, on the factual side, the judge found, based on the evidence that he saw, that this was a valid business transaction between an attorney and a client. Now, the judge also ruled, and it's a second ruling of law, that even if there had been a breach of fiduciary duty, and he purposely writes in, but there was not, Ms. Foley would be barred by the statute of limitations. And that issue in this case is dependent on a string of facts that happened after, undisputed facts that happened after the 98 signing of the trust. And as fully briefed, Ms. Foley's breach of fiduciary duty claim, there's a 3-year statute of limitations. She filed in January 17th, would have to have discovered the harm by after January of 2014. There's also a 93A claim that was dismissed too, 4-year statute. I'm more concerned for this appeal on the breach of fiduciary duty statute of limitations argument. It's an actual knowledge standard, meaning the plaintiff has to know of the harm. Well, if you read through the trial record, first, the trial judge found that Ms. Foley knew of the transaction from the beginning. So if she had any problems after that, she should have filed years and years ago. But if you look through the trial record, and all this is undisputed, trust was entered in 98. From 2003 through 2017, Ms. Foley executed tax forms, tax returns for the trust. And these tax returns, they contain K1s, and the court knows what K1s are. Each one of these K1s included Mr. Foley had a 25% interest in the trust, which would be a 25% interest in the trust res, the Gallivan property. She began executing these tax returns in 2003. So she would have been noticed then that something's going on. I mean, during this whole case, Ms. Foley's theory of what happened has changed. She pled originally that she thought she was just letting Mr. TEVNAN use her room. And then it changed that he was going to be her lawyer for the building. So by 2003, if she was signing documents that showed he had a beneficial interest in the trust, that should have indicated to her there was harm. So we have that. In 2008, one of the K1s inaccurately listed Mr. TEVNAN's ownership interest at 50%. She changed it, and this is an evidence, and I give the record appendix site if you need it. She changes it to 75-25. So clearly she knows he has some kind of ownership interest. She can't plead ignorance to that. That should have alerted her to the harm. And as the cases in this field for discovery rule, harm analysis. It's when somebody first learns of the harm, not the extent of the harm or the full extent of the harm. So she should have known. We first think 2003. Then it was 2009. 2010, Mr. Foley prior had left the building due to a noxious fumes problem. 2010, Ms. Foley writes a couple of letters to him asking for rent. And in one of them, she says, I'll take your rent from the capital account. Now, the supposedly unsophisticated person is talking about a capital account. What capital account? If she had any reasonable belief back then something was going on, that would trigger the statute of limitations.
I think the argument, and this is more broadly put, whether it's statute of limitations or on merits, is she knew he was a 25% owner. She didn't know that he could force the sale. That's the argument I'm hearing today.
Right, and the judge found that she understood the trust agreement from '98. She had been a trustee of a prior nominee trust in the early '90s. The trust document, which she executed, was reviewed with Mr. TEVNAN and with this attorney Colin before. So now she's saying 18 years. She sued Mr. Attorney TEVNAN 18 years after that she suddenly didn't understand how the trust document worked. And that because there could be a termination, that a beneficiary could terminate the trust or the trust could lapse due to time, that it was somehow divesting her of the property. I don't see how that, if the judge found she understood the trust from the time of its execution, from then on, it's a business transaction between two individuals. And the fact that one or the other in this business could, for lack of a better term, terminate the business is I think, irrelevant to, did Mr. Attorney TEVNAN breach his fiduciary duty to Ms. Foley back in '98, which Judge Ellman found no. So with the statute of limitations, I don't think my brother is making the argument that the termination clause is the harm she didn't figure out. I think his argument, or my argument, is any harm. I mean, if her theory is he never was a beneficial owner, any of these occurrences that happened, and I've left a few out, but they've been briefed, should have opened her eyes to the fact that there was something was going on with the trust. So I understand Justice Sullivan's question. I don't think that applied to the statute of limitations. I don't think Judge Ullman applied that. Judge Ullman basically said that from the execution, she was aware of what was going on. So she blew the statute or missed the statute by 15 years. There's some other arguments raised by my brother. In his brief, I feel that he's raising an argument that perhaps the Pollock line of cases, there needs to be a change of the law in that a client and attorney, after they enter into a business relationship, there can never be a fiduciary duty running from the client to the attorney. Pollock and Marshall and the line of cases going all the way back to Israel, they contemplate that. The rule of ethics contemplate that. That's the whole point of these rules of this common law. So once you do the right thing, right, going forward, there could be fiduciary duties running from the client to the lawyer. One would assume, and as I said in my brief, that a lot of times these business relationships are partnerships. Well, there would be duties running between client to lawyer. I gleaned from his brief, I think in his brief, he's trying to say we want to extend the law or change existing law to create a new carve-out for public policy. And I don't want to misinterpret what Mr. Wynn said. And our position is that the trial judge found Mr. TEVNAN did everything he was supposed to do. Okay. He then was a beneficial owner of a trust. Okay. After that, it's like any business relationship. He shouldn't be held to a different standard after the creation of the business transaction if he did not breach any ethical rules, and if he fulfilled the elements of Pollock and those line of cases. There's a great case that when I was preparing last night, I ran across. It's Merrick versus Reuben. And I will, if the court allows me, file a 16L letter. And it's right on point. It's a.
Thank you, Attorney Giannis. We will look forward to seeing that citation. The case is submitted. 2019 P589, Richard D. Bostwick versus 44 Chestnut Street and others. Bostwick, you may begin.
Yes. Can you hear me?
Yes.
Okay. My name is Richard D. Bostwick. I'm a pro se plaintiff appellant and a citizen of Massachusetts in the United States. As a citizen, I have a duty to remedy the constitutional and statutory violations by 1, the big banks, which affects hundreds of thousands of families. Number 2, state and administrative agencies, which affects thousands of Massachusetts families. And 3, to provide guidance and uphold the integrity of the Commonwealth court system, which affects thousands of Massachusetts families. And 3, to provide. I guess I'm getting feedback. As stated by stating the Commonwealth court system, I mean the lower court, Middlesex Superior Court, and appeals court defendants. For me, it has been 19.5 years of litigation in the Commonwealth and federal courts. The defendants and these litigations have resulted in damage to my health, career, finances, and relationships. In my first case, I spent $79,000 on 4 lawyers who wrote the first complaint and asked the court for more time. After running out of money, I became pro se. I pray that this appeals court will allow Bostwick's amended reply brief and its 163-page argument. Please be informed that I don't see the timer and I just see myself on the screen. Am I being heard?
You have 12 minutes and 45 seconds left. You can switch to gallery view and you will see all of the panel members and the other attorneys and the timer.
No problem. I'll continue in the current state. The lower court has 21 defendants. The time for my oral argument is 15 minutes. Consequently, I'll provide an executive summary and then followed by the details. One issue in this appeals court and Middlesex Superior Court case is the reasonable accommodation, discrimination, and retaliation and coercion against Bostwick under the American with Disabilities Act. Bostwick suffers bias, discrimination, physical and emotional distress disabilities caused by the actions of Middlesex Superior Court and this appeals court under ADA Count 6, which are related to the denial of Bostwick's rights under the Supremacy Clause, judges bound by the Constitution, right to petition, due process, regulatory taking, bill of attainder, no excessive fines, and equal protections. These ADA violations concern case 1775, 56, 36 in the appeals courts, 13P, 296, 219, and 0589. And these are identified in Bostwick's brief and reply brief. And Bostwick's demands for damages are identified in count 6. The fact of retaliation is determined by the jury. So a question for the panel is as follows. The statement is, as a consequence of these ADA violations, the entire case below, case number 5636, is voidable. So for this issue, Bostwick's detailed arguments follow. I have about 6 pages of notes, and I'll try to go through those quickly. In count 6 of the lower court case, Bostwick claimed ADA damages against Middlesex Superior in the appeals court. These damages include loss of rents of $828,000, property value of $403,000, ADA damages of $300,000.
Mr. Bostwick, could you just help me out for a minute to understand? I understand that you have causes of action and that you have damages. Could you explain to us what the disability is that you rely upon for purposes of the ADA?
Yes. Basically, the disability is related to the emotional distress, consequences resulting in stroke and heart palpitations. These have affected my ability to perform and do work and concentrate.
Okay, so suffered as a consequence of?
The actions by the defendants and demands of the litigations.
Okay, thank you. Please continue.
Basically, all of this is in the reply brief. I'm running out of time. So basically, the state has no immunity.
8.5 minutes.
The state has no immunity from these Title II claims. The reply brief talks about the areas and reasons of the discrimination, and also gives about 14 different examples of why, what happened with the judges in the lower courts. And Bostwick is concerned that the lower courts had to dismiss all of Bostwick's lower court case counts to protect the Middlesex Superior Court and the Appeals Court from the threat of their ADA liabilities in count 6. And please refer to the detailed arguments in Bostwick's brief and amended reply brief. And it's 163 pages of arguments concerning Bostwick's 1.5 years of litigation. So another issue concerns the Department of Public Health and Hunter in the official capacity and the Title 1983 Hunter, Lasky, and Levin. Bostwick is deprived of his constitutional rights under the Supremacy Clause, judges bound by the Constitution, right to petition, due process, regular taking, bill of attainder, no excessive fines, and equal protection. Bostwick is deprived of the right to the liberty of renting and selling his property. Bostwick claims damages includes the loss of rents of $828,000, property value $403,000, emotional distress of $300,000. No children resided or were ever harmed at Bostwick's residence. Concerning the unauthorized letting without licenses or permits by Sims and Classic, Bostwick is entitled to a Department of Public Health adjudicatory hearing under General Law 11-197B, lead paint inspectors, deleditors, licensure. After Bostwick's report of unlicensed letting to the Department of Public Health, childhood lead poisoning director Hunter, and the following Department of Public Health supervised inspections, Bostwick was entitled to a Department of Public Health adjudicatory hearing under State Sanitary Code 105 CMR 410-850. Given the unauthorized letting by Sims and Classic, Hunter and the Department of Public Health stated that Bostwick's only option for renting is an unauthorized letting letter. A UDL means that the letter of full compliance or internal control can never be issued for 44 Chestnut Street in Bostwick, and all future property owners are subject to strict liability for a lead-poisoned child forever. Several questions for the panel are as follows. These are the questions, the statements, and I don't know if we have time for answers, but a conflict of law exists between 105 CMR 410-850 and 105 CMR 46900, where the Supremacy Clause rules for 105 CMR 410-850. No conflict of the law exists for General Law 11175B. The Department of Health waived its sovereign immunity by its breach of its promissory estoppel contract with Bostwick. The contract is expressed both oral and written by the 02 September 2008 CLPPP complaint, 2, the ongoing internet stigma publication, 3, the deposition of Paul Hunter. The contract is implied in fact and implied in constitutional law, for example, constitutional due process and taking. For renting of Bostwick's multiple family, the promissory estoppel contract demanded the letting at a cost of $270,888, resulting in a UDL with a strict liability forever. However, the Department of Public Health breached the contract by its denial of Bostwick's legal right to a Department of Public Health adjudicatory hearing under General Law 11197B and 105 CMR 41050. The Title 42 1983 persons, Hunter, Lasky, and Levin, waived their qualified immunity. There is no compelling government interest in the 1983 person demands are objectively unreasonable to include a letter of unauthorized letting oral contract, 21 December 2007, deposition of Hunter, ongoing internet stigma publication. The 1983 persons violated Bostwick's legal right to a Department of Public Health adjudicatory hearing under General Law 11197B and 105 CMR 410-850. Bostwick's property has UDL and strict liability for a lead-poisoned child forever claimed against it. Consequently, Bostwick's right to rent and sell his multifamily was constitutionally taken without compensation, due process, and equal protection. The taking by the 1983 persons was objectively unreasonable, not discretionary, and knowingly willful. Bostwick argues that all the lower court judges dismissed all of Bostwick's claims against Sims and Classic unauthorized letting at Bostwick residence to protect the interest of the Department of Public Health. Another issue concerns Santander Bank, Sovereign Bank, and Fannie Mae. Several questions for the panel are as follows. Under General Law 235-13, Bostwick may bring an action for a breach of covenant for damages and equity against Santander and Fannie Mae instead of suing for or against the penalty. In addition, on the quantum merit theory of recovery, Bostwick may sue the defendants for the fair value of the work that he has done concerning A, protecting the title to Bostwick residents, and B, preventing property sale, environmental damage violations by Santander and Fannie Mae. Santander and Fannie Mae no longer have a legal interest in Bostwick's property and cannot bring an action to foreclose, said Judge Courtney. Bostwick is entitled to an independent foreclosure review at no cost.
Mr. Bostwick, you have about a minute and a half left.
Okay. The Superior Court 2015 case dismissed Bostwick's wrongful for foreclosure claims under res judicata from the Superior Court 2009 case. Then I have information on Lansford C, Sims, and Bernard and Bates. Pertaining to Bernard and Bates, there was discovery of violations under General Law 142A9C, and therefore, pertaining to the statute of limitations, Bostwick didn't find out this information from Consumer Affairs until 24 January 2014, when Bostwick discovered the lost evidence of Bates, Bernard, and Gant. Consequently, there's no statute of limitations for the claims in count 11 of fraudulent concealment, misrepresentations, fiduciary negligence, and negligence of infliction of emotional distress. Thank you for your time and supporting both me and others in your legal service to the state and the country to promote justice.
Thank you, Mr. Bostwick. Attorney Salzberg, you may proceed.
Thank you, Justice Green. So I'll address the res judicata issue, which is what is at the core of Mr. Bostwick's claims against Santander and Fannie Mae. As to the constitutional and ADA violations, we rely on our briefing, which is on page 24 to 29 of Santander and Fannie Mae's brief. Now, as to the res judicata issue, Mr. Bostwick brought the original 2009 action on the facts and circumstances surrounding Santander's authority to foreclose on the property. Now, that was triggered by an SCRA complaint that was filed in the land court, but at the time that Mr. Bostwick filed the 2009 action, the foreclosure hadn't taken place. So Judge Curran, when Santander and Fannie Mae moved for summary judgment, Judge Curran granted summary judgment to Santander and Fannie Mae on the basis of the fact that the argument was not ripe yet. However, if the court were to read the Wright Machinery v. Seaman and Wall case, a 1974 case from the SJC, that case says that even though the basis for granting the summary judgment in 2009 was the not ripe argument, the fact that summary judgment operates as a binding adjudication of the claims that were raised means that the court, which is Judge Curran, has examined the pleadings, and I focus on the word the pleadings, as well as any affidavits filed in opposition to the summary judgment motion, to determine that even if the facts set forth in the pleadings and the affidavit were true, they would not be legally sufficient such that it could go to a jury to try the facts. And that
I'm sorry, what case did you just write?
It's Wright Machinery v. Seaman and Wall, 364 Mass 683. It's a 1974 case, Justice Shin.
And you're saying that that case stands for the proposition that when earlier claim is dismissed as not right, that constitutes an adjudication on the merits for purposes of res judicata?
Yes, because again, if we go also, not just that case, but also we go to Harker v. Holyoke that says res judicata binds the parties on claims that were raised and that could have been raised in prior proceedings.
But it could not have been raised if it wasn't ripe. I'm not really understanding that.
So, Your Honor, the complaint in the 2009 action did raise the issue of whether Santander had standing to foreclose on the property, and that was based on an assignment that was included in the complaint. So, Judge Curran, at the summary judgment stage, the burden on him is, his duty says that he's not just supposed to read what's in the summary judgment motion, it's also the pleadings has to be read. And that's what the Wright Machinery case said. So while I can't be in Judge Curran's mind when he ruled on the summary judgment motion, the Wright Machinery case says that summary judgment is a binding adjudication of all the issues that could have been raised.
But I mean, I'm looking at your brief and the citation and the parenthetical to Wright Machinery. It doesn't say anything about unripe claims. I mean, summary judgment is certainly a decision on the merits, but an unripe claim could not have been brought in the earlier action.
So I missed the last part of yours.
A claim that is not right could not have been brought in the earlier action. And it is clear from Judge Curran's decision and R128 affirming that decision that that was the basis for his grant of summary judgment on that issue.
Yes, Your Honor. And as to the unripe claims, on page 21 of Santander's brief, we've cited a string cite of several cases where the issue of whether an issue, a claim in particular, was ripe can be a basis of res judicata. So
but the question of whether it was ripe, it can be is res judicata, but a dismissal of a claim because it's unripe is not an adjudication on the merits.
sorry, I missed the first half of your.
I said the dismissal of a claim because it is not a dismissal of a claim on grounds of ripeness is not an adjudication on the merits.
Right. So you're exactly right, Judge Green, because that what you're talking about is dismissal of the claim in 2015 by Judge Desmond was a res judicata purpose. But what I think I was trying to address with Judge Shin's question is in the 2009 summary judgment order, which was an adjudication on the merits. So the motion to dismiss that Judge Desmond ruled on the basis of res judicata, that was based on the fact that Judge Desmond determined that the 2009 summary.
It's difficult for me to see how dismissal of a claim is not ripe is an adjudication on the merits. So let's just accept that it's not an adjudication on the merits, the earlier dismissal by Judge Curran.
Okay.
So I just want to clarify. So this complaint in this case was filed in late 2015 and amended once in late 2015. Is that correct?
Yes, Your Honor.
And at that point, the foreclosure hadn't occurred. Is that right?
Correct. The foreclosure happened in April of 2016.
It still was not ripe at the moment that the case was filed.
Yes. However, there was motion practice after, in fact, a land court case was brought by Mr. Bostwick after the foreclosure happened. And that land court case was initiated, again, on this basis of, on the basis of the authority to foreclose. That case was brought in 2016, a month after the foreclosure. And in fact, Judge Henry in the 2015 case also heard a post-foreclosure hearing motion on Mr. Bostwick's motion to stay. So even after the foreclosure, there were two hearings on
the foreclosure was in April 2016. Is that correct?
Yes, Your Honor.
Okay. And in his brief, he alleges that he moved to amend the complaint to add allegations concerning the foreclosure. Now, as far as I could tell from the docket, that motion to amend was not made until after judgment had entered against your clients. Is that correct?
Correct, Your Honor.
Okay, thank you.
Your Honor, my time I see is up, so I'll.
Okay, thank you. We'll hear from Attorney Gekas. You have to unmute yourself.
Sorry. Our position here is very straightforward. So Orleans was foreclosure counsel for Santander. We were pretty much just thrown into the caption, but there are no specific claims or allegations anywhere in the complaint against Orleans. And the case law is very clear that a law firm cannot be held liable for claims brought up against its client. So for these reasons, the trial court properly allowed our motion to dismiss, and that decision should be affirmed.
Thank you.
Thank you.
Attorney Lavoie.
Yes, Your Honor. Unfortunately, I'm on by phone, so I can't see the timer, but I hopefully won't need that much time.
You'll be fortunate if you can finish within that time.
Excellent. Your Honor, I represented Mr. Sims, the defendant carpenter who started this whole thing by Mr. Bostwick's claims. We've been litigating with him since 2004. We tried the case, which had claims of fraud, breach of contract, 93A, breach of warranty, unjust enrichment, before Judge Krupp in March of 2014. A verdict for the defendant, verdict on the 93A by Judge Krupp. That was appealed, docket 2014 P1277. That was dismissed by the court on appeal with prejudice. Mr. Bostwick appealed to the single justice. That was to vacate that dismissal. That was denied. He was offered the opportunity to go to the SJC. He did not. He then filed this second case. Judge Desmond, you have the ruling, granted summary judgment on claim preclusion, issue preclusion. Mr. Bostwick has filed a third case against Mr. Sims in federal court. That was summary judgment on claim preclusion. Res judicata was granted to Mr. Sims. So I would just ask that the court follow the prior rulings and uphold the findings in favor of Sims and end this long ordeal. Thank you.
You're welcome. Thank you. All right. That gets us to Attorney Simran.
Thank you, Judge. Appellant's amended complaint includes multiple claims against appellees Bates and Barnard, who responded with a motion to dismiss. Judge Desmond, in a well-reasoned Superior Court opinion, dismissed all claims against my clients. We are here on Mr. Bostwick's appeal.
Could I ask you a very basic background? This is Judge Shin. Who are your clients? What is their association? I'm assuming they're associated with Classic Group.
That is correct. They are the principals of Classic Group.
Thank you.
In his amended complaint, appellant's claims divide into three categories. State law claims alleging breach of contract, tortious injury, and 93A violations are precluded because the complaint filed in 2015 was filed years after the alleged breach occurred or the alleged injury occurred, or after the discovery rules triggering statutes of limitation had run. Bankruptcy court claims alleging violation of the automatic stay are precluded by federal res judicata doctrine. The order dismissing the adversary proceeding was final. The causes of action alleged in the bankruptcy court and in the current complaint are identical. The parties to those actions are identical. And finally, the remaining claims should be dismissed. The ADA claim brought against my clients implausibly alleges that they acted as public entities. The civil rights claim brought against my client implausibly alleges that the appellants acted under color of state law. And finally, the lead poisoning claim.
On your brief.
I'm sorry?
You have your brief for the remainder of your arguments. Your time has expired.
Okay, thank you, Judge.
Attorney Fee.
Yes, I'm here on behalf of the Commonwealth defendants, the Department of Public Health or DPH, and DPH employees Paul Hunter, Warren Lasky, and Donna Levin, as well as the Middlesex Superior Court and the Appeals Court. Your Honors, the Superior Court correctly dismissed all claims against the Commonwealth defendants. The claims fall into two categories, and I'll take each in turn. First, the claims brought against DPH and the individual DPH employees were correctly dismissed based on claim preclusion. The Superior Court correctly found that Mr. Bostwick's civil rights claims against DPH and the individual DPH employees were barred by claim preclusion because Mr. Bostwick had previously, as some of the other attorneys this afternoon mentioned, brought a claim against DPH challenging the same enforcement action and underlying decisions in May 2010 that was dismissed in March 2011 by Judge Wilkins in the Superior Court. As such, the elements of claim preclusion are met. DPH was sued in that previous case. The DPH employees are in privity with DPH. While the claims here are characterized as civil rights claims, they do challenge the same enforcement action, the same decisions. And there was certainly a final judgment in that prior case. In our papers, we also argue alternative grounds for dismissal, including statute of limitations, sovereign immunity, failure to state a claim, and qualified immunity. I'll rest on my papers for those arguments at pages 23 to 28 of the Commonwealth's defendant's brief. Secondly, with respect to the Middlesex Superior Court and the Appeals Court, the Superior Court correctly dismissed Mr. Bostwick's civil rights claims and claims of ADA violations against those defendants as well. With respect to the civil rights claims, they were barred. The Superior Court correctly found that they were barred by both sovereign immunity and absolute judicial immunity. With respect to
what are we to do with the fact that we are being asked to resolve a claim brought against the Appeals Court?
Well, I would ask that I don't believe any of you are involved in any of the claims or allegations, and I believe that this panel is able to uphold the decision of the Superior Court regardless.
But there's a claim for damages directly against the Appeals Court, right?
Yes, Your Honor, that's correct.
So how do we resolve that?
I believe that the case law is clear that the appeals court is completely immune from the claims that were brought.
No, I understand that, but how do we resolve a claim for damages against ourselves?
I can come back to you with more briefing on that issue if the court requires.
Okay, thank you.
We rest on our papers for the rest of the ADA violation claims.